Hello, my name is Todd Hutchison from Perth-based legal and business advisory firm Balfour. In this short session, I want to touch on the contract challenges currently of concern in Australia related to the coronavirus. This unfortunate event is reportedly going to impact the Australian economy in the billions of dollars. See, manufacturers and suppliers particularly are looking into their legal obligations relating to a failure of supply, effectively a potential breach of the contract. The supply of materials and products either being delayed, detained, or otherwise unable to be manufactured that are under contract are causing high-value construction, mining, and other critical infrastructure projects to become challenged in their execution. This is generally a result of attempts to mitigate the spread of the virus through risk treatments such as closing borders, implementing a range of travel bans, and causing closures or delays in the supply chain and logistics channels. The question by suppliers that is being asked is whether the force majeure clauses are needed in a contract or whether the supplier contract can be terminated under frustration. Well, the general answer is the force majeure clauses are required to be expressed in the contract, and they have to be suitably structured to adequately cover for such events. Without a force majeure clause, the supplier is risking being in breach of contract where damage claims may be possible despite the event being out of the supplier's control. Where the force majeure clause is in the contract, the general principles surrounding a force majeure event look to whether the event was outside the party's reasonable control, whether it was not reasonably foreseeable that the event would occur, and whether the party was either not in a position to or was unable to prevent the consequences of the event. Now, reasonable control in this context would need to consider if alternate supply options were possible. Some suppliers who have not been protected by force majeure clauses may be looking towards the doctrine of frustration, as they feel that the virus has impacted supply through no fault by either party. Well, see, frustration generally occurs where the party does not satisfy their own contractual obligations, where certain conditions or circumstances made it impossible to perform the contract. In this case, the contract becomes frustrated. This is not a way to avoid liability. Where a contract becomes frustrated, the party that has suffered loss can likely recover this loss by seeking damages in the courts. Where a contract has become frustrated, it can be terminated at the point of frustration. The contract obligations, however, do not become void from the beginning of the contract, only for future obligations that are discharged. This means that losses leading up to and at the point of frustration can still be claimed.